Thank you, Shreya. And hi, everyone. Nice to see you all again. Welcome, Tripti. Welcome back. Just to quickly introduce everyone, Tripti, this is a very diverse group of people who have come together. As you know, you already know about our Aarohan program. This time round in our audience, we have people with lived experiences, we have palliative care beneficiaries, caregivers, well-wishers, doctors, and even some lawyers. So everybody committed to bringing about a change, and we're very happy to have you with us. To introduce Tripti, Tripti is a practicing lawyer. She's based out of Delhi, and she's been associated with a human rights law organization called Lawyers Collective for 2 decades now. And she's been working on drug policy and human rights for more than 10 years. And she engages in litigation, legislative advocacy, and research. Tripti is very special to us, particularly because she has really worked closely with all the champions who work towards amending the Narcotic Drugs and Psychotropic Substances Act of 1985, which was a major barrier to access to opioids and essential narcotic drugs for a long, long time. And it was with this concerted effort that this law was amended in 2014. The rules were brought in 2015. We felt that part of the Aarohan program, it was very important for us to take you through this particular journey because it demonstrates just how difficult and challenging changing or amending a law can be. But Tripti was very essential to the whole fight. She contributed towards drafting the health-oriented amendments to the NDPS, and which were finally adopted in the Indian Parliament in 2014. So Tripti is here to take us through that whole journey, and I'm sure we have a lot to learn from it. I'm sure many people in the audience have engaged in legislative advocacy battles of their own. So we're here to mutually learn, and I'm pretty sure this will be a very fruitful session. So Tripti, over to you.
Thank you, Smriti, and thank you, Shreya, for inviting me yet again. I'm really pleased to be here with all of you. And this is really together recounting the journey, the arduous journey that we undertook to change, like really make the impossible possible. Changing the NDPS Act was nothing short of impossible, as you will hear from me over the course of today's discussion. And yet we together made that happen. So my presentation will be, of course, the advocacy journey, but in that I will also maybe just reorient or familiarize or reinforce some concepts of the drug law. Some of you may be familiar, for some of you it may be new. But please feel free to stop me if you feel it is getting a little technical. I will try and avoid that, but just some basic information which will be critical to understanding what our journey for amending the law was like. And Shreya, you will be helping with my slides?
Yes, my colleague Vaishnav would be sharing.
Okay. Vaishnav, I will just let you know when to turn. So, yeah, next, please. I don't see the slides. Yeah, okay, great, thank you. So really, just this is very basic. Of course, pain relief is an active part of palliative care. And the situation that we were in, say, 10 years ago was that though medicines for relieving pain they existed, they were available, but they were not available to doctors and patients in India. And the issue really was not identified by lawyers, but it was identified by doctors who were really struggling, seeing their patients needlessly suffer pain which was unavoidable. So the issue with the law was the lack of access to medicines. So next, please. And why were medicines not available? This is where really, again, the understanding of doctors came in. It wasn't, mind you, lawyers who identified this, but it was doctors like Dr. Raj Gopal who, through their thorough analysis, revealed that it was after India adopted the drug law, the Narcotic Drugs and Psychotropic Substances Act in 1985, that the availability of morphine for medical use fell drastically by over 97% from where it was in 1985 to when it was examined in 1997. And of course, the number of patients requiring pain intervention and medicines only increased in that time, but consumption really fell drastically. And this, it was for doctors to then identify that this trend has coincided with the coming into force of the act and its very rigorous enforcement by our police and our courts. Next, please. So, what is the NDPS Act really? It was enacted because India had signed certain agreements internationally which obliged the country to introduce a certain set of norms and regulations around narcotic drugs and psychotropic substances. So, India's law is a little peculiar because, as many of you would recall, we had for centuries, we had opium cultivation and trade regulated by the British colonial government. So we already had a system of control and regulation over opium, which was then superimposed by the international conventions in the form of the NDPS Act. So our act today, even today, is a mixture of the British colonial law and concepts that have come through international drug conventions. And of course, it has been enriched and tweaked according to judicial interpretation. But fundamentally, colonial law and international agreements are the basis of the law. The NDPS Act seeks to prohibit, control, and regulate. And please mark these words. Sometimes these words appear to be contradictory. If something is prohibited, how can it be regulated? It sounds that it can't be, but this act actually has a framework that on the one hand completely outlaws certain things, but on the other also introduces ways and means by which the same activities which are otherwise prohibited and banned can be undertaken. And what are the activities which are subject to either prohibition or control or regulation? It is pretty much everything to do with narcotic drugs and psychotropic substances, from cultivation, if it is plant-based substances, to manufacture in factories or labs, to possession, sale, purchase, transport, stocking, use, consumption, import, export, everything, all the activities to do with drugs are subject to the prohibitory and regulatory framework. Now, apart from the Act, which is quite voluminous and complex in itself, the NDPS law is also supported by rules. Now, rules are a delegated legislation, which basically tells us how to operationalize certain activities. So the law will say do this, but how should it be done is laid down in rules. And under the NDPS Act, we have what is called central rules, or rules framed by the government of India, which apply throughout the country, as well as rules framed by each state government, whether it's Kerala, Karnataka, Maharashtra. So there's the Act, and then there are the central and the state rules. So this is really the framework of the law. Next, please. Now, the NDPS Act essentially covers three types of drugs, and the difference between them is often one of nomenclature, if you ask me honestly, but I will try and explain what is the basis of differentiation in the law. So the first category is narcotic drugs. Now, these are firstly the three the plant-based substances. So the plants, cannabis and its constituent parts and components, such as ganja, hashish, that is cannabis. These are narcotic drugs. The second category is the coca plant and products derived from that, most commonly cocaine. And the third plant is the opium poppy and all the products derived from that, whether it's opium, whether it's morphine, whether it's poppy seeds, etc. So that is one, one broad category of substances considered to be narcotic substances. Then there is a second level of substances that are under narcotic drugs, and these are what are called manufactured drugs. Now, this is a term that we have taken from the British colonial law, and therefore it's very confusing, especially when, I was talking to some international researchers who are working with us. They just couldn't figure out what the hell is this, but this is, shows how our law is a pretty complex structure. So manufactured drugs are essentially drugs that are listed by the government in a list which comes in the NDPS Act. And a lot of the medicinal drugs or, synthetic products of, synthetic opioids or semi-synthetic are part of manufactured drugs. So, and I will just come to this in the next slide, that there is considerable overlap between these categories. But it's important to note that narcotics are plants, 3 plants, their products, and then a category of substances listed as manufactured drugs. The second category of drugs covered under the NDPS Act are called psychotropic substances. And both narcotic and psychotropic are really, they affect, their mind altering. So at one level, there is no difference. But the difference in psychotropic substances are that plants themselves are not included, but only products of the plants are. Now, here again, you will see that the substances that are listed as psychotropic substances, this is again a list under the Act, has drugs which are medicines as well as those which do not have medicinal properties as of now. So like LSD, methamphetamine, purely as of now used for recreational purposes, as well as certain medical drugs like, the recent entrants like ketamine and more recently tramadol are treated as psychotropic substances. Then there is a third category called control substances, and this is again a difference from, the term used internationally, where internationally any substance which is under the International Drug Convention is considered a controlled substance, but in India that is not the case. Our law defines as a controlled substance any chemical which is used for the manufacture of either narcotic drugs or psychotropic substance. It does not have narcotic or psychotropic substances in themselves, but they are like precursors. And again, these are notified by the government. So under the law, while some categories are fixed, some categories are things that the government can add and remove from the list without having to resort to parliamentary amendments. So typically, like the latest inclusion of tramadol, which is also a pain relieving medicine, did not require any parliamentary procedure to be followed. The government simply did it by virtue of notification. So it's easy if you are able to convince the government to do something in that sense. But certain things require us to go back to the parliament, and I will come to that in a little more detail later. Next, please. So this, I think, is very important for me to lay down, because the general perception, whether it is what we read in the press or even the understanding of the police or lawyers or judges, is that narcotic drugs and psychotropic substances are illegal. These are illegal drugs, illicit drugs. Anything to do with these drugs means you go to jail. But actually, drugs in themselves are not legal or illegal. It is not that a particular drug is illegal or legal. It is what it is used for that determines whether it is lawful or unlawful. And the legality really depends on, firstly, like I said, what is it used for? What is the purpose? And our law, just like the international conventions, says that a medical purpose, using a narcotic drug for a medical purpose is legitimate. Using a psychotropic drug for a medical purpose is legitimate. So therefore, if it is used for a legitimate purpose, it is the activity is legitimate. Then it's not a question of the drug being illegal, it is the purpose. But apart from the purpose, there is a second criteria which we must follow in order to fulfill the legality criteria, and that is the manner in which the drug was procured and used. And this has to be in accordance with the NDPS Act, with the NDPS rules. And if the Act and the rules require you to have a license or an authorization, then the terms and conditions of that license or authorization. So let me take a contemporary example. I think we've been privy to news, and the media has also had a couple of discussions on this about cannabis. So medical use of cannabis. Now, most people say, oh, cannabis is illegal. But like I said, cannabis in itself is not legal or illegal. And our law does allow medical use of cannabis. So if I say I am a patient and my doctor has prescribed me cannabis for a particular medical condition, it is perfectly legitimate for me to possess that cannabis for my medical use. However, if the law says that in order for me to have that cannabis, I must only buy it from a government shop, and I don't do that. I buy it from an illegal dealer because it's easier to get it from a dealer than from a government shop. It is not legal. So the drug may be legal, the use may be legal, but if it is procured from an unlicensed person, the whole thing becomes illegal. So it is really these aspects which often get lost in the popular discourse and narrative around drugs, but very, very more so because you're all concerned with the medical use of narcotic substances. It's very, very important that you understand these concepts. So really, it is not so much about whether the drug is legal or not, whether the drug is a medical drug or not. It is more to do with whether the use of the drug is medical or not. So this is another dimension which is important to know, is because many times, and this has often been argued in court, that I have codeine. Now codeine is a pharmaceutical drug, so it's a medical drug, it's a legal drug. But if I have it without authorization and codeine is a narcotic drug under the NDPS Act, I am liable for prosecution. Then I can't escape and take the color, as it has, many people have tried this in court, but there have been recent decisions clearly laying down that it may be what you call a medical drug, but so long as it is part of the NDPS Act, and if you have contravened any condition of the NDPS Act, including possession without a medical prescription if the law requires a prescription, or getting it from an illegitimate source, or having in your possession quantity which you're not supposed to have, all of that is a violation of the NDPS Act, and you are liable for prosecution and punishment. So very, very important to bear these concepts in mind. Next, please. Now, as far as our issue is concerned, which is really availability of medical opioids, what was the problem in the law? as we saw it. So, and this is something that I'm, talking more as a lawyer, but the health dimensions of it, which will come to later. So, like I mentioned, the NDPS Act has a complex category of classifying drugs, and many of the opioids that we are concerned with for the purposes of pain relief fall under overlapping categories under the law. So many opioids would fall under the definition of an opium derivative. In the same opium derivative is also heroin. So many of these drugs that we are talking about and we are concerned with is in the same category as heroin. But they are also part of what I called manufactured drugs, the list that the government has. At the same time, some of these are not, they are salts and preparations of an opioid. So therefore, they come under another category called preparation containing manufactured drug. And all of these are subsumed under the definition of narcotic drugs. I know I'm perhaps not making sense, but really the law also doesn't make sense on this. But the fact is that we have a very, very complex structure of introducing and understanding these drugs in the definitions section itself. The second problem with the law was that, like I mentioned, uh, drugs can be regulated and controlled, especially those for medical uses. The law allows their regulation and availability. However, regulatory powers there is a division in the law, and that division itself is very complicated. So that division, whether it is division between different drugs or it is division between different authorities of the central government and the state government, it's a real mishmash. So to give you an example, psychotropic substances, which also include a lot of medical drugs that we use, the power to frame rules over psychotropic substances, how can they be manufactured, how can they be procured, how can they be used, how can they be supplied, etc. All of this is vested in the government of India, the central government under the NDPS Act. And in the NDPS Act, it says that this should be done in accordance with the Drugs and Cosmetics Act. So as far as psychotropic substances are concerned, their regulation is really what is laid down in the Medicinal Drugs Act, which is called the Drugs and Cosmetics Act, and that framework, which is, not a patch on the NDPS Act in terms of its stringency is concerned. But as far as the drugs that we are primarily concerned with, such as morphine and some of its derivatives, those fall under the category of manufactured drugs. Now, as far as manufactured drugs are concerned, the rule-making authority is divided between the central government and the state government. So as far as making these drugs are concerned or manufacture, the central rules apply. But as far as all other activities, including the activities that we as medical providers are concerned with, such as possession, use, consumption, the state rules apply. And each state has its own rules. So you can understand how complex the legal architecture is. Even the prohibitory part is quite simple under the NDPS Act. You have a drug, you have no authorization, straight away to prison. That's fairly simple. But in accessing what is lawful, what is a lawful activity, which is medical use, which is part of our right to health and so important for life, that is a really, really complex structure. Next, please. So, like I said, in accessing medical opioids, it is allowed, but it has to be done in accordance with the act and the rules. And the devil lies in the detail, and the detail is in the rules. So prior to the amendment of the law, access to morphine, and I will just take the example of morphine, not mention other drugs that maybe you all use. So for accessing morphine, you had to deal with the state NDPS rules. Now, the state NDPS rules had, like I said, different multiple activities. So imagine I am a hospital and I need to keep a stock of injectable or oral morphine with me. In that action of keeping morphine tablets or injections with me, what are the activities that I am engaged in? Possession. So the law has possession, I am in possession. I need to buy from somewhere, some manufacturer, some pharmacy. So I am engaged in purchase. If I have to get the drug from somewhere, say the factory or the warehouse or the pharmacy, there is transport involved. The drug has to come from one place to the other. So it is transshipment of the drug. Then if I am prescribing the drugs, then I am using, it is used. And if the patient is being administered, then there is consumption. So these are multiple activities. It may seem like, okay, I'm a hospital, I have drugs and I prescribe to the patient. This is very simple from the medical perspective, but from the legal perspective, from the NDPS perspective, you are engaged in multiple activities at that time, which are the concern of the law. Now, all these different activities required different licenses. So you had to have a license or authorization to purchase. You had to have an authorization to be able to dispense to your patients. You had to have another authorization if the drug had to come from outside the state, so on and so forth. And then thirdly, different activities, different licenses from different agencies. So a license for transshipment from one government agency, license for stocking, one government agency, license for approving how much quantity of morphine can I stock, another different government agency. So this was the scenario. Then there were some states which had just unbelievably onerous requirements for someone to use morphine medically. Like I vividly remember this seeing the Goa government's affidavit, which was filed in the Supreme Court in one of the cases brought on by the palliative care doctors. And the Goa NDPS rules back then required the patient to personally go with their prescription for morphine to the district collector, get it stamped, and then go to the pharmacy, procure the drug for whatever duration, whether it was 2 weeks or 3 weeks, then repeat the same process for the next round. So imagine, people in pain being made to do this, but this was really the state of affairs. Then there was another problem, which was the inconsistency between states. So, like I mentioned, every state has its own set of rules. And while some states followed a common pattern, several states had very different requirements. So, in some states, it was the excise department, which is really, it's really like the taxation department. It is a department that deals with things like alcohol. So that department was also dealing with permissions and authorization for accessing medical morphine. In some states, it was a totally different agency, such as the state drug controller. And you often had to make sure that there's coordination between these different departments, especially if you're getting drugs from one state to the other. Now, needless to say, this was a very, very difficult task. Then fourthly, we had this peculiar aspect in our law, which is that bringing from one state to the other means this is import and export interstate. So although we should have free movement of people and goods, at least within our borders, for narcotic and psychotropic substances, the law has this category of import interstate and export interstate. And remind you, this is coming from the British colonial times. With different provinces and the opium trade between different provinces at that time. So this is something we have still retained. So which means that hospital in Karnataka, which was getting morphine from a factory in Maharashtra, the Maharashtra supplier and the Karnataka user had to have multiple licenses and all valid at the same time in order for that transaction to be within the purview of the NDPS Act. And this was really quite a task. Then we also had a situation where some states had thought that narcotics are just bad things. Then there is no need for anyone to use them. So the state of Punjab, for example, did not have any rules to allow medical access. They only introduced the NDPS rules back in 2012 after the palliative care community's litigation in the Supreme Court. So for some states, this was just not an issue because narcotics are bad things. And then finally, some states had this very, peculiar thing, which is part of the India's international reporting requirements, but they would arbitrarily allocate a quota. Okay, you can stock morphine, but this is your quota. Now, if I have more patients or I need to dispense more because the need of the patient is such, nothing doing. It is a quota fixed by a bureaucrat and I have to stick to that. So next, please. Overall, if you see, and this is something that the palliative care doctors, this is their slide, this is not really, this is how they saw the regulatory requirements for accessing morphine and other opioids for medical use. Really a nightmare. You don't know where to enter and you don't know where to exit, and you're just lost in this labyrinth of licenses and permissions and authorizations. Next, please. And this is, I hope this is, the text is visible. This is really from, I think, Dr. Rajgopal's articles on access to opioids in India, and this is where the whole mess that I described earlier is written about. That different licenses, different agencies, and all valid at the same time. Even if one license expires, it means your perfectly lawful transaction gets the color of illegality, and if it gets the color of illegality, it means you're subject to stringent punishments under the NDPS Act. And all of this onerous licensing system, coupled with the impossibility of having valid licenses all at the same time, and the fear of inviting prosecution and penalties, ultimately meant that no one wanted to use these drugs. Doctors did not want to stock them, hospitals wanted to stay away, and as a result, we had the situation that we were in, with patients not having access to pain relief. Next, please. So what was being done to change this? I think, and some of this is before I started associating with Dr. Rajgopal. This is, some of their efforts prior to that in the 1990s, once they realized that the NDPS Act is the real barrier in access to pain relief medication. The group of doctors went to see the regulatory authority in the government of India, which is the Department of Revenue in the Ministry of Finance, and talk to them about this is the problem and we need a simplified licensing system. So, like I mentioned, it was not for the government to make rules, not the Indian government, it was for state governments to make rules on this subject. So, what the Department of Revenue did was they came up with an advisory, something called model rules, and they sent it to all the states saying, here is what we think should be the framework, but you're free to use it, because ultimately the power was with the states and not the center. The center could only nudge them, advise them gently, tell them what to do. So this simplified model rules was circulated to the states in 1998, and I think over perhaps a 10-year period, some states did adopt, or maybe some states adopted in bits and pieces, but and on the basis of whether the palliative doctors were working there or not. But by and large, the situation really didn't change very much. The palliative care community also resorted to litigation, approached the Delhi High Court back in 1998, which was mostly about individual patients who were not getting access to morphine, so their family members, their caregivers approaching the court and also getting orders. I must say the court didn't turn them down, but again, this was limited in its effect. The larger policy change, the larger structural change, really did not happen. Looking at the law and really thinking about changing the law was something that happened much later. The idea that we could actually think about reforming the NDPS Act, I think, came several years later. And by this time, Dr. Raj Gopal and I and others in the palliative care fraternity were kind of, we knew each other and were working together. And this idea really happened when the government on its own moved amendments to the NDPS Act back in 2011, but not in the context of medical access. That was really some other amendments trying to make the law more stringent, bringing in certain provisions for property forfeiture and others, had nothing to do with medical access. That was not even an issue on their agenda. Next, please. So it was at this time when we came together and we said, look, the law is before the parliament. There are changes being suggested. Why don't we bring our issue also on the table and say, if you're amending the law, also bring in amendments to make medical access a reality for us. And this is when we started working with the government and with other policymakers. And our work was premised around the following principles. The first was that medical use of narcotic drugs is not only permitted, so it is allowed in the law, but actually the drug conventions on which the NDPS Act is founded says that such use is indispensable for the health and welfare of mankind. So while governments have only been talking about preventing addiction and preventing misuse, they have completely lost sight of the second goal, which is that medical access must be available for people, for humanity. That there is no question of getting rid of these drugs, but it is a question of using these drugs for a rightful, legitimate purpose, which is pain relief. And this is what is enshrined in the international drug control policies and is called the principle of balance, which means that you balance out your duty to ensure that drugs are available for those who need it and at the same time are not available for misuse or other unwanted purposes. And this is a balance. Mostly the balance has tilted in the favor of controlling and preventing misuse. It has never been on the side of ensuring balance, and it was ensuring medical access, and it was time to tilt the scales. We also really impressed upon the government that we are not saying that the law doesn't allow, and mind you, several countries, the law doesn't allow medical access. Our law does, including cannabis that I mentioned earlier. But the provisions that allow have not received adequate attention or have been underutilized, and the provisions that are more about prohibiting and stopping the supply, etc., those have been overemphasized, and it's really time to rethink this balance. Then another very useful argument which we were able to present is that India is the leading supplier of opium raw material, and it is our opium poppy, and it is our products from our factory which go on to supply the pain relief needs of the rest of the world. But our own people don't have it. Patients in our country don't have it, whereas we are supplying to the rest of the world. And then lastly, we were able to show, and thanks to the work of Dr. Rajgopal and Pirium India, that it is possible to have a system where patients have access and where there is no diversion or misuse. So the fact that you can have regulations that work was borne home by the Kerala example. And this was really, really tough because most officials, and you're probably familiar with this, have this attitude, oh, in India we can't do this. India, we can't regulate anything. The only way to control something is to ban it. Like regulation seems to be very alien to us. So it was really, using the Kerala example to say, look, you can regulate it effectively. And there is very little scope for diversion and misuse if you have proper checks and balances and you have a well-functioning system. Next, please. So, with these principles and arguments at hand, we engage with different bodies and different parts of the legislative system, and held a series of meetings, made a whole lot of submissions. Only yesterday I was looking at my folder archives now, the number of submissions and changes, and oh, this is right, no, we should say this and that, and actual drafting of amendments. I remember, so the first part of our battle was really convincing the government that, look, there is already a bill pending in Parliament. Let's use it to also bring in amendments for medical access. And we tried very hard. There were a series of meetings, and we were finally told, no, it's too late now. You try in the next round. So this is like a, door shut on us. But we really said, no, it's now or never. There is an opportunity. Let's not let go of it. And then came, the further advocacy, which I'll just come to. And we managed to convince the government that you can pursue this also in this round of amendments. And that's when there was a call from the Department of Revenue saying, okay, we agree to amendments, give us the language, give us the draft, what would you like changed in the law? And that is when, I sat and we just drafted something and discussed it with Dr. Rajgopal and others, and we had language and a draft to present to the government. And of course, that was just one part of the work. The rest of the part was really about garnering larger public support, getting the attention of members of parliament, that this is an important issue and that this is something that the country really needs to act upon. And this is where there were a number of letters. Just go to the next slide, please. Number of letters, including from cancer patients, their families, their other survivors, editorials, posters, a whole lot of advocacy that went on to informing people in power that you need to act And now I can just, say that in a lighter note that, we send so many letters. Unfortunately, I couldn't find one on my system, but I remember that there were a large number of letters that cancer survivors and their families had sent to the government, to the finance minister, to the UPA chairperson back then. And the ministry officials were just flooded. Every day they would receive post and letters. And one of the officers once called and said, "Oh, you guys are sending so many letters, but at least make the letters slightly different. Even the spelling mistakes are common." The different letters that we are receiving. So anyway, I think what was important was that everybody really came on board, and we said, this is our chance, and let's do it. Let's go all out, and let's not leave any stone unturned. And next, please. And the pressure really worked. And I don't know if you can read the text, but this is an article that was published in 2012, when we finally succeeded in getting a nod from the government that they will take up the medical access amendments. And the last para in this article says, Finance Minister P. Chidambaram has fast-tracked the changes following hectic lobbying from civil society and intervention by the UPA chairperson Sonia Gandhi. So really, it was those set of letters and postcards, all of that with the spelling mistakes that really made a difference. Next, please. And all of this worked finally when in 2014, on its last day before dissolution of the Lok Sabha, when the NDPS Amendment Act was passed by both houses unanimously, and everyone agreeing, whether it was the treasury benches or the opposition, that this was something the country really needed to do, that we owe it to our people, to our patients, that that this change happen, and people have access to what they need to relieve pain and suffering. And the amended act came into force in May 2014. Next, please. And in March, I think once again highlighting the work that all of us had done with the government. This is a statement that the then finance secretary made at a high level convening in Vienna of the Commission of Narcotic Drugs, where each country is mostly talking about its own law enforcement efforts, but for a change, the Indian government really talked about the NDPS amendment and how the country had gotten the law wrong. And in the pink, you will see the secretary saying, "I'm happy to announce that Parliament has very recently passed amendments and which will enable uniform and simplified rules and leading to removal of the regulatory barriers that have acted as hindrances to availability of such drugs." And then in the underlined portion, it says, "Such amendments were drafted with the active participation of civil society and the palliative care community." So really, all of you who are present today acknowledged at Vienna. And the last line saying, "With these amendments, our drug enactment incorporates the principle of balance espoused by the UN Drug Control Convention." So really very proud moment for all of us who worked for this. Next, please. So very briefly, what were these, the health-oriented changes in the 2014 amendment? The first was that we introduced a new category of drugs, and maybe some of you will say, "Oh my God, another category in already complex structure." But yeah, this is something we did, called essential narcotic drugs, which the central government could notify and control. And the second change was that as far as essential narcotic drugs were concerned, all regulatory powers would vest with the central government and not with the state government, which would mean that there'll be uniform provisions around this. And the third, and perhaps, something which is not often talked about, but for me as a lawyer, I think it's the most important, was that the object of the NDPS Act, which had so far been about prohibiting and controlling illicit drugs, was broadened to include promoting the medical and scientific use of narcotic drugs and psychotropic substances. So, this was really saying that while prohibition is one part of the law, ensuring access is another and equally important part, which cannot be lost sight of in its enforcement. Next, please. So, what was the thinking behind this concept of essential narcotic drugs? And since this was something that I'd worked on, I can tell you, one had to really navigate between the complex category of narcotic drugs, which is associated with outright criminality, and the concept of manufactured drugs, where there was an element of regulation. At the same time, we were not concerned with all manufactured drugs. We were only concerned with a select few, like morphine and some others needed for pain relief, and not the whole host of other drugs, which are used for other medical purposes, but not pain relief. So, this category of essential narcotic drugs allowed us to create a different set which could be handled by the central government without affecting the other drugs which are really handled by the state government. We didn't want the whole thing to come because the center was not really ready to take on the whole responsibility. But they were happy to take care of some drugs which are needed for pain relief, and that's what this concept really tried to do. We use the word essential really to convey that these drugs are indispensable, like I said, that they are needed, badly needed, and you can't ignore that need. Another very important thing was that we fashioned the amendments in a way that the government could change or add to this list without resorting to the parliament. Like I said, this is a very important part, because tomorrow if there is another analgesic, another pain relief medication which the medical community feels is necessary and must be made widely available, then one can lobby with the government and say bring that also onto this list, and you don't have to resort to any parliamentary amendment to do that. You can really do it through the government and a notification. And of course, the medical community's opinion, views, research, published literature, all of that is important. Essential narcotic drugs now have uniform rules, and very importantly, because this was a concern for the government, that we don't want to dilute the punitive structure, because if there is diversion, if there is misuse, we want the law to apply as it would for any other narcotic drug. So we agreed to that, and through this categorization of essential narcotic drugs, we were able to take care of that aspect also. Next, please. So then a year later, the government notified some drugs as essential narcotic drugs. I'm sure you are familiar with this. Next, please. And then followed up with the central rules, which then really, override the state rules on as far as essential narcotic drugs are concerned. And the rules are largely based on what was practiced in Kerala, and I'll just come to that. But of course, there are still some very problematic aspects in these rules which were overlooked at the time that they were being drafted, and that need fixing, and that really is something we need to work on. Next, please. I don't know why this new procedure, just to enter, maybe the bullets will come. No? Yeah, thanks. So no, just go back to the, yeah. So under the old procedure, like I said, multiple licenses required. Now only one document required. So if I want to stock and dispense and sell essential narcotic drugs as a medical institution, all I need is one document, which is the certificate as an RMI or recognized medical institution. No multiple licenses, no multiple agencies, only one single agency, that's the state drug controller. Earlier, the licenses had different validity periods and they were largely smaller periods. Now, the certificate is valid for 3 years and it can be renewed. And lastly, of course, we don't have different procedures. It's just one procedure that every state has to follow. Next, please. This is my last slide. So really, just some thoughts as I went through this amazing journey for today's meeting. I think some highlights that really stand out are that firstly, drug policy making is something where civil society and medical community or human rights people have had no role to play. The governments have mostly have had this attitude that drugs are a subject of international control, and there are a whole lot of international processes and bureaucracy, etc., that needs to be followed. And what does civil society have to say about this? Drugs are bad and they should be prohibited. So this was the first time, I think, in India where civil society played a major part in fashioning changes to the NDPS Act. And, and our role, as I showed you, was also acknowledged, not just nationally, but internationally also, that these are changes moved by the Palliative Care Society and groups working there. And as we were interacting with the system, a very intractable system, which I would say still is to some extent, the attitude was always about, we need to control, we need to clamp down, we don't want people to have easy access. So for us, going then saying no, we need easy access, was really, really difficult, because you thought you were making progress in convincing them, and then suddenly there'll be this question, but what about this? Shouldn't this be kept under so much control? Who is responsible if there is diversion? Why should we not have? So it was really just getting them to see this other side of drug control, of drug use, was really, really hard. And it still is. You still go to the government despite all these changes, and that is the only tune that they tend to sing. So it is a constant battle to draw attention to this very important but neglected aspect of drug control. And then it was also quite a task to connect what was happening to patients to the law and legal procedure. And this is still true to some extent, because if you go to the government, if you go to the Department of Revenue, and we've gone, Smriti's also been to them several times, the officers will really say, but we've changed the law. If you people are not prescribing, what is the law got to do with it? And they don't realize that if people are not prescribing, if doctors are afraid to prescribe an essential medicine, surely the law has a role to play. So it was really hard trying to convince them to see. And like I said, for a long time, they said there's no need to change the law. Maybe you change medical curriculum, maybe you need to educate your doctors that these medicines are safe to use, you need to generate demand. The law has nothing to do with it, it allows. But really, the devil was in the detail, and it was quite a task to convince them that this was really the case. Then I think we were also, as a group, quite fortunate to have both technical and legal competence on the subject. So, and this is where, there were so many times where, like, the doctors would say, but we, an RMI will do. And then it was for me to really help and explain and say, what does the RMI really do? In terms of the law, the RMI is engaged in possession, it is engaged in purchase, it is engaged in supply, it is engaged in distribution, it is also engaged in sale. All of these activities must be accounted for. The law that you make has to cover everything. You can't just say, okay, we'll give you a possession license, because a possession license doesn't take care of the other things like sale and purchase and things like that. And also, there were things that I didn't know as a lawyer. For instance, the fact that what happens to the unused supply of narcotic medicines when a patient passes away. If the patient is only authorized to possess and the patient is no more, those medicines then become unlawful. It is unauthorized possession. So I had no idea that this was something to work upon, until doctors told me that in Kerala they have a system of what to do with the unused medication. And I said, okay, this is very important. So when we were working on the rules, we kind of put it to the government that this is also something you need to take care of. Otherwise, the law will again start haunting, the families and the bereaved members in the patient's family. So and then of course it was good that we just didn't go there as doctors, that we had the support of other stakeholders. And I must mention the pharmaceutical industry, especially the Indian Drug Manufacturers Association, did play a very important role. And they were, so what we were saying from the side of the providers and the patients, they were pretty much reiterating from the side of the suppliers, the medical suppliers, the manufacturers, and that system. And while of course there were some points of disagreement, and there were some points where their take was different from ours, but by and large there was consensus, and we all agreed that we need to move forward on this one together, and that really helped. And then lastly, I think it was really that commitment and determination to make sure this happens. And again, I vividly remember now this one meeting that we had at the Department of Revenue in the North Block. I think Dr. Rajgopal was there, Dr. Sushma Bhatnagar, and a few members from the IEMA were present. And that was the time when we were told, sorry, this is too late. The amendment is in advanced stages in Parliament and not in this round. You will have to wait for the next round of amendments. Whenever that happens, we'll take it up. And our faces really fell. And we said, what is this? We've come this far. And now again, the door is shut. And I think it was after that meeting, we all went back home really sour-faced and unhappy. But something happened, and I can't recall who, but somebody called up someone else and said, let's not give up. Let's keep trying, and let's really, get them to see, not from us, but from people who are suffering, that this is a very real problem and it needs to be resolved, and needs to be resolved now. And this is when the idea of getting patients and survivors and families to send letters, to inundate the powers that be with our communication. That was the idea. And like I mentioned to you, it was that communication, that direct advocacy from survivors and sufferers that really made this happen. So it was really about not giving up. And ultimately, victory lies with people who don't give up. So that is something our experience also showed. So thank you. That's about it from me.
Thank you, Tripti. Every time I hear this story, I have goosebumps. On the outset, it just seems like this really technical law, changing a law and stuff. But every time I hear the story, whether it's from you or Dr. Raj or anybody, it's just hair-raising, because 19 odd years, and really it's a story of a miracle. You started out by saying that it seemed so impossible, and there were so many obstacles along the way, and the persistence, and I think the game changer, like you said, was the involvement of civil society. And that is the message that is so important to this group here, because this is a group of people who is so keen to affect change. And I hope that they don't go through something as draconian, as something as horrendously monstrous as the experience that all of you went through. But I think what emerged out of all of that is that you can actually change something if enough people come together. And I think the stakeholder collaboration was just phenomenal. Personally, I remember that day when it was passed in the Rajya Sabha. If I'm not mistaken, it was the last bill to be passed. And the last bill by the Rajya Sabha on the last day, and after that, the government changed. So it was literally the last thing that that government passed. And I remember getting this message at 5:37 from Dr. Raj saying, just simply, it's done. But those two words, I still get emotional about it, because the fight to change this absolutely draconian law started 2 years, and I'm going to, like, personally, I've shared this before, started 2 years before my mother got sick. And went on for 14 years after she died. And I remember thinking at that point that, we had never had access to pain relief. And now finally there was some light at the end of the tunnel where people maybe wouldn't have to go through what we endured. So I remember that being a very, very emotional day, both personally and professionally. The reality now is that, like you said, the law has been amended and the rules have, been changed. But the reality is still a little bit difficult, because when we talk to a lot of state governments, most people seem completely oblivious to the fact that things have changed. And then that, again, like I said in a previous session, becomes our job to go and advocate and say, listen, this is what you're working with now. And just yesterday, I was on a call with some people who wanted to bring about, wanted to start a palliative care service, were not sure. Then when we got on the meeting with them, said, I don't know what this palliative care is. What is it? So we started to tell them about it. And when we got to the part of the opioids, there was this instant, no, 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 that's not what we want to do. And these are two senior doctors, retired doctors. That was the response we got. And, we said, okay, let's talk about that in a bit. Said, yeah, but if you guys are peddling opioids to us, then we don't want to work with you. That was literally the message. So a lot of changes, a lot of work still to be done. And Dr. Raj and I are part of this working group that is putting together indicators for palliative care in low and middle income countries. And even now, in spite of the fact that there is so much conversation around prohibition versus access, very often we're the ones on the table who say just having the law in the country is not enough. You can't just have an input indicator. You have to have a process indicator and an output indicator, because India is an example of that. That just because you put in a law doesn't mean everyone will follow it. So those are the conversations that are happening at other levels, but of course at a very basic local level, a lot of our doctors, a lot of our own family members still need to be educated. So the fight is not done, but I think the biggest part of the fight was fought. And thank you, Tripti, for being such an integral part of it and for sharing the story with everyone today. So I'm now going to invite questions. There are a few in the chat box, which I'll just bring up for you. Are the elder care facilities allowed to apply for an RMI certificate to enable them to purchase, stock, and administer drugs needed for palliative care? So that's one question. Tripti, do you want to? Yeah.
Should we take a couple of questions, or you want me to answer?
Happy to have you answer.
Okay, so under the rule now for essential narcotic drugs, any medical institution, and let me just tell you what a medical institution is under the law. It is It means a hospital, dispensary, clinic, or an institution by whatever name called. So, very important, whatever name called, that offers services or facilities requiring diagnosis, treatment, or care of illness, disease, injury, deformity, or abnormality, um, and established by the government or any person or body of persons. So the name really doesn't matter. So if you're an elderly care facility, it's all right, but it's important that you are either providing inpatient medical services or even outpatient medical services, but you must be providing medical services. And these services are, like I said, for diagnosis, treatment, of care of illness, disease, or injury. So if it's just a residential facility without any medical care, then you're not eligible. But if you have elements of medical care also in your facility, then you are eligible to apply for an RMI certificate. Now, for having an RMI certificate, you need to designate one of your doctors, and this has to be a doctor, it can't be a non medical person, it has to be a medical practitioner who is trained in pain relief and palliative care. So that requirement is also necessary to be fulfilled. So it's all right if it's an elderly care, but like I said, medical services and then having a doctor who is trained in palliative care and pain relief. Now, what is this training has been a bit of a question mark for all these years. Several of you may know this better than me, that the government first was trying to come up with some sort of a training program, then it got shelved. Then some of us said that, but then aren't they trained in their medical school and in their MBBS and MD degrees? Isn't that good enough? Do you need additional training? And what should that training look like? So all of these questions are really up in the air. There is no clarity, and I can tell you that different state drug controllers have different approaches. So some say, of course, every doctor is trained. We don't need any special training. But some are insisting on seeing some certificate course or some government agency saying that you have undergone some kind of training. So yeah, that gray area is there. But having said that, if you satisfy these criteria, a medical service and having a designated doctor, you should be able to get a certificate.
Thank you. That answers my question. Uh, I was recently in Chennai visiting an elder care facility where they have all the facilities, including a physiotherapy lab, and as well as a place if one of the inpatient, persons who's living there passes away, they also have VIP room. They call it, I mean, very humorous way. They call it the parlor, where they can keep the body. It's almost like a mortuary. It's a place where they just call in the body till the hospital to which they are connected can come and take the body away in an ambulance and keep it in the official mortuary. So they actually have a 24-hour doctor on call, as well as a hospital which is having a 24-hour response team available for them for any of the elders staying there in the facility. So I suppose if they can, if the hospital that they are tied up with has something of an element of palliative care, then they can probably do the necessary thing for prescribing or administering the drugs if needed to any of the elders staying in the facility.
No, I'm afraid that may not be possible, because the facility that has gotten the RMI certificate, only they can dispense. So
Okay,
being
okay,
attached to a hospital does not mean that you can
will
stop
not.
dispense. Yeah, you need to
Right.
be a medical facility yourself and have the certificate. And it very clearly says the rules that one facility cannot sell or loan out medicines to another. So
Fair enough.
yeah,
So this RMI certificate, is it something that an elder care facility can apply for? I mean, have you come across any such uh, facility where they have already got an RMI license? I haven't personally tried to
I'm
find
not
out, but
aware,
in your experience,
but maybe Smriti and others will know. I've really, this is the first time that I've
yeah,
heard the question. But
okay,
like I said, you have to be providing medical services. If you're not providing, if it's simply a care facility, and there's a doctor who comes on call, but the doctor is not
yes,
really housed in that facility, then maybe it won't qualify as a medical facility itself. So medical
okay,
care must be
okay.
an integral part of the facility.
Thank you. Okay,
There is a question that I want to know whether the NDPS Act permits the dispensing of oral morphine in home care services. I would imagine, Dr. Ajayan, that uh, that is permitted, provided that the home care service runs out of a facility that has an RMI status. Tripti, could you corroborate that?
Yeah, home care services can be provided. There's a special, provision that deals with home care treatment, and it says that it requires that you can provide home care treatment to a patient who is registered with an RMI. So that is the first requirement, and the RMI must depute a qualified personnel to go to the home or the residence or place of stay, and that place of stay may be permanent or temporary. I think that's important because several patients come to a particular city only for a
Yeah.
period of time for medical services. So this is important, and um, the 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 person who's authorized must have uh, the permission of the designated in charge. So the doctor who is the designated doctor in that RMI, whose responsibility it is to oversee the essential narcotic drug stocking and dispensation, they must, I suppose, explicitly by, say, a letter or some sort of an order, authorize that personnel to visit the home of the patient and carry a specified quantity of narcotic drugs for the patient. And the unused medicines must be brought back from the patient's home and brought back to the RMI and handed over to the designated doctor in charge. So these are the few requirements under the law.
Um, when dealing with a state that has still not properly implemented the amended rules, would approaching the High Court for relief be an appropriate course of action is a question.
Yes, absolutely, it would be, and this is now, like I said, these are official rules which every state has to follow. There is no question of a state government saying no, we are not going to follow this. This is a central act and central rules, and every state has to abide by that. Also, I had briefly mentioned that the Palliative Care Association had filed a PIL in the Supreme Court back in 2007. This is much before we explored the law reform opportunity. And that PIL, went on for several years. And, that's when there was a lot of back and forth between what the states were doing and what they were supposed to do. So once the law was amended and it was brought to the attention of the Supreme Court that the law is now amended, so the court then closed the case, but with the caveat that any outstanding issues, the parties are free to come back and use litigation for that. So you could go to the Supreme Court, but it is just now, the court is often saying go to the High Court first, especially if it's not a pan-India issue. If it's an issue that concerns a particular state, it is advisable to go to the High Court. So I think that's a very, very feasible, in fact, much, much needed strategy. Let me also take this opportunity to just introduce some research that we did last year using the RTI Act to just get a sense of how the rules are being followed, the essential narcotic drugs. So from out of the 34 states and union territories, only 15, so less than half, had issued RMI certificates under the NDPS rules. So more than half of the country is still not following this, not doing this. And we also found interesting variations. And again, it shows, I think when I was discussing with Dr. Rajgopal, he was saying it really shows the strength of the palliative care movement in a particular state. So like a small state like Delhi had issued 184 RMI certificates, which is quite good considering the size of Delhi. But a large state like Maharashtra had only issued 4 RMI certificates. So, clearly disproportionate. And this is just territorially. I mean, I have no way of knowing the number of patients, but obviously large states would have larger number of patients in need. So there is a lot of discrepancy. We also found that some states still following the old rules, refusing to comply with the central rules. So there is the next line of things to be done on this, and approaching the High Court would be a good strategy, in my opinion.
Also, we had the experience in a state where they had come up to them and said, okay, we need to see your floor plans, which is not mentioned in any of the RMI requirements. And so these guys were just getting stuck in that. So finally they got in touch with us. And as a WHO collaborating center for training and access to training and policy on access to pain relief, we actually wrote to that drug controller and just to sort of bring his attention to the new rules and said, what you're asking for is not entirely legal, it's not part of the ambit. And that actually propelled him to issue the license. So that is also recourse in some sense. But because it was just, for us, it was quite funny that they were, not funny, but it was quite bizarre that they were asking for that. We have we'll just take a couple of more questions as we have just very little time left. Here in our state, the High Court of Chennai declared the suggestions and advices from the State Human Rights Commission is binding on the state and to be implemented. At present, we have proactive members in the commission. Please let me know how we can use this opportunity to take up very important issues to the commission. Is a question from Saeed.
I think this is a great idea of using the Human Rights Commission, because access to pain relief is a matter of human rights. Human beings should not suffer needlessly. We all have a right to live, and to live with dignity, and to live free of pain. And if you can really approach the commission and get them to agree to see this as a human rights issue and as an issue that deserves their active attention and engagement, I think nothing like it. There is I'm sure Pallium India can help you, and I can also help in getting some good material both nationally and internationally on how pain relief is a subject of human rights law. And I think it's a great suggestion. Please move forward with this if you can.
Wonderful. There are Pranabda and Dr. Rakesh have asked about the training. Just to address that, like Tripti has also mentioned, that there is still some, we don't have consensus on exactly what that training should be, because different organizations, different bodies are providing different training courses. So we have the 6-week program, we have the 10-day program, we have the IAPC courses, all of that. At the moment, there is some work happening between various major organizations in the country that provide training. So between the IAPC, Pallium India, Can Support, MNJ, and various other big organizations in the country, we are working together to arrive at some sort of consensus, and we will then be advocating for that to be recognized. So to answer your question, we don't have any, sorry, there's a little bit of disturbance. Yeah, so that's where we're at the moment. Having said that, RMIs have been dispensed. If you, Pranabda Shantanu's hospice in West Bengal has received an RMI license now. So it's not that it's not possible. Like Tripti also mentioned, the different states recognize different levels of training. So we just have to work with that for the moment.
Smriti, may I also just add that, one state where I think at the invitation of Pallium India only, I had gone for a training. It was Haryana last to last year. And the state drug controller had come to listen to my session and then also add on. And it was fascinating. So the state of Haryana has been issuing RMI licenses, but mostly to large private institutions, healthcare institutions. And his bias towards these institutions was so blatant and open, because in the course of the training, and the training was for primary healthcare and community healthcare personnel, to train them on issues of palliative care and pain relief. And he kept saying that if it's a large private hospital, of course the doctors are trained there. I don't need to ask for anything. But for smaller facilities like a care center or a palliative care hospice, I'm not sure what training their staff has undergone. I'm not sure who is there. And then he kept saying that, you people are too small. You shouldn't be bothered about these medicines. What will you get out of keeping all this? So many complications and this and that. You just do your basic work. Let the bigger hospitals handle this. So he was, like outrightly dissuading the team of people who, Pallium was trying to train. Issue. Don't do it. Stay away. It's too complicated.
We've seen unfortunately we've had too many of these like slightly bizarre experiences, and so much of it is also cultural and our perception. So in some places, I mean, I know of a place where right now it's the drug inspectors who are making things difficult. They're probably out for a handout or something, but the drug controller probably doesn't know that the drug inspectors are causing not sabotaging it, but putting barriers in the way, probably because a little bit of palm greasing is required or something. So there are several layers to this, and if we are not educated, now we've had the good fortune of having gone through this whole NDPS session with you. It's for a lot of people, it's just too convoluted from the outside. So a lot of people are not, so when someone comes and says, oh, you are asking for opioids, oh, do you know what that means? And they pull out all the punitive sort of things associated with it. Punjab, of course, because of its other issue, even though the rules apply, the culture is a little bit antagonistic, right? So even your pharmacist is not going to help you out over there. So it's very cultural. I had this incredible experience in Arunachal where it's a whole other ball game there. So it's a matter of working within the communities that we can influence. I think now that we have a firmer grip on our own understanding of the law, it is important for us to also take this forward. And I think one of the major parts of our work is to constantly impart exactly this kind of information, so it's a little clearer. And so that's where we are right now. And I think we are at the end of our time. So I'm going to say thank you very much, Tripti. I know there might be a few more questions that people have. Please feel free to write them in to us, and we will forward them to Tripti, or we will try and answer them ourselves, the answers to which we know. So Thank you all very much for your participation. And Tripti, thank you again for everything that you've done. I think thanks to people like you, the face of palliative care in the country has changed. So you have our deepest appreciation and thank you.
Thank you. Thanks.
Thank you, Tripti. Your last year session was one of the most watched sessions of Aarohan. So we had all our project officers at